record to the cloud. Hi, we are going to do a recording and a speed review for you for state content. We are in this handout that we've been in the last day and a half, and we are going to start on page 3. Just a quick reminder, when you get to the test center, make sure you print your certificate from this course. Tomorrow afternoon, when we're done, I will get those done within an hour of us completing this course. You'll take that certificate, and when you take the exam, you're going to do the state exam first. It will be based off of 40 questions. You need a 70% to pass, which means you need a minimum score of 28. You've got 60 minutes to complete this. So you've got more than a minute per question. That should give you plenty of time. Now, under license requirements, maintenance, and education on page 4. 8 test questions here. And the first thing I want you to know on page 4, under administration, is the mission of the Real Estate Commission is to protect the public. Another way they might ask that is, how does the Real Estate Commission protect the public? It's by setting licensing standards, maintenance standards, and disciplinary standards. It might say something like that. Great test question. We know who needs a real estate license. We've been reviewing that. But there are 3 major exceptions I think that you should review on page 5. You need a real estate license to represent someone in the buying, selling, and leasing of a property, except you don't need a license if you're a for sale by owner. Again, we call that a FSBO and FSBO. You also don't need a license if you're someone's power of attorney. Remember, that's written legal authorization for someone to act on your behalf. We gave styles of questions like, if you've got power of attorney to sell someone's house and you get an offer, do you need to wait for them to come home? Do you need to contact their family attorney? No, you're the POA, you're authorized to take care of it. The third one I would highlight that does not need a real estate license is a property manager who lives on site and their management is related to their JOB. An on-site property manager. Page 6, for a salesperson's license application. I know you guys have this probably memorized as you're working through this process. In terms of the 60-hour class, those 3 12-hour classes, the background check, E&O insurance. But here's the big ones that I think that you need to make sure you remember. Number 1, you've got to pick a broker before you apply. You cannot apply for your real estate license inactive. You've got to have a broker that wants to sponsor you. Next up is you've got to be 18 years of age or older. They will try to mess with you on the exam. I would anticipate make you think 21. No, the number is 18. The other one that you might see multiple times is the one that says an applicant is not ineligible because of citizenship, sex, race, religion, marital status, or national origin. And I know you know that list from fair housing, but citizenship is the new one, right? That's not part of fair housing. So they're not ineligible because of citizenship, but the application may require citizenship information. That means that if they apply and their visa expires, that doesn't necessarily mean their real estate license expires, because citizenship isn't a requirement. So that doesn't mean that they necessarily go together. And then also remember, all licenses are issued for 3 years. The first year counts as a full year no matter what. Hold on. All that and Hazel's boyfriend had to show up when we're recording, the UPS man. I didn't want to get her barking all over. 3-year term, first year counts as a full year, no matter when you get your license, and all licenses expire December 31st. So you get your license in January, June, August, December. No matter what month it is, the first year counts as a full year. Okay. Then under broker license application on page 7, the same rules apply. 18 years of age. The applicant is not ineligible because of citizenship, although it might be required on the application to fill out. Their license also is renewed every 3 years. And the first year counts as a full year, and everything always expires December 31st. All licenses expire December 31st in Iowa. What is unique about the broker's license is they've got to do 60 hours of education. But the main thing is they've got to be actively licensed for the 24 months preceding their application. And remember, I love you, but 24 months equals 2 years. Just in case, I don't know, you have a brain moment, that's the same thing. It doesn't matter your volume or the number of transactions, you've got to be actively licensed for the 24 months preceding application. Then the other thing I had you add there for both licenses is you've got to apply for your license. You've got to apply for the license. The deadline after you pass the exam is the last day of the 6th calendar month. The last day on the 6th calendar month. So if I pass today, January 14th, I've got to February, March, April, May, June, July 31st to apply for my license. Under license maintenance and renewal, the very bottom of page 7. When you renew your license, you need a minimum of 36 hours of continuing education. And the other thing to note for the exam is instead of doing your continuing education, your CEs, you can apply with the commission and take the exam instead. Top of page 8. When you renew your license of those 36 hours, 8 of them must be law update, 4 of them must be ethics, the other 24 can be electives. And then I added there, for your knowledge, of those 36 hours, make sure at least 12 of them are live, a classroom like Zoom. The rest could be self-paced if you wanted. Under licensee renewal requirements, again on page 8, if you fail to do your continuing education, you should still renew your license by December 31st. You will renew it as an inactive status, and they give you a grace period of 30 days, which would be January 30th, and a $25 penalty. Now, when we say grace period, you're inactive, which means you're not selling real estate. The grace period means they're not requiring you to start all over with a brand new application. So the grace is application, not an active license. Don't confuse that, please. Then you've got up to 3 years that you could pay that $25 a month penalty. And after that, if you don't reinstate, you got to start from scratch. On page 10, license termination and transfer. If you want to transfer your license and remain active, step 1 is you got to have a new broker agree to take you on. Step 2 is you've got to have your current broker release you. And step 3, you've got to authorize that transfer. Now, this is done electronically now, but I want you to think of it as though it's a piece of paper you walk around town with. You take it to the new broker that you're going to, they say, yes, we'll take you. You take it to the old broker, they sign and release you, and then you complete the transfer with your signature. Disciplinary actions. The bottom of page 11. We've been talking about this one, I feel like, in almost every section of this handout. But remember, the contracts belong to your broker. So if you leave your brokerage, you don't take them with you when you go. They do technically belong to your broker. You're working as an appointed agent in that transaction, representing a client on behalf of your broker. The other thing that your broker controls is the commissions. So if someone says, man, you did a great job, we'd like to give you a $500 bonus, you cannot take that money. It's got to go to your broker, it's got to be documented, and everybody signs off on it. So you cannot take that bonus directly. The other things of significance in this section is page 13, that very first bullet point in the middle. Once the commission gets a complaint, their first step is what I think you should know. And their first step is to determine whether the complaint is factual and actually presents a violation of the law. Which means your client can't file a complaint because you didn't bring them Starbies the day of closing. There's no law that says you've got to take Starbies to your client at closing, right? So they would read that complaint and be like, not a fact that presents a violation of a law. So I would know that is the first step. The other thing that I think is really key for you to review is in the middle of page 14, hearing on charges. Hearing on charges. Before the commission can sit down and have a hearing about your complaint, they've got to give you a 20-day notice. 20-day notice, and then you've got 10 days to respond to that. I had you add that to your notes. You've got 10 days to respond to it, which means if you don't respond and you don't show up, too bad, so sad. Page 14, I would review what they can do to discipline you. What actions can they take against you? My highlights for you are revoke and suspend your license. Those are two options. They can require additional continuing education. They can order a physical or a mental examination. And then another style of something that you should know is they can impose a civil penalty for a maximum of $2,500 per violation. Not $5,000, but $2,500 per violation. And then I believe I had you add your notes here. It might have been somewhere else. I believe I had you add to your notes that you're allowed 3 violations in 3 years before they would take your license. I would also review some of the things that they consider when giving you a disciplinary action. Have you done this violation before? When was the last time you had a complaint filed against you? How well did you cooperate with the real estate commission? What was your financial gain, or what was the harm to the public? How severe was it? I would highlight those. Then on page 16 at the very top, this talks about some prohibited practices. Now, we've talked about contracts and commissions belong to the broker. Then you get paid according to your independent contractor agreement. We've talked about dual agency, always needing to be disclosed. Another big prohibited practice is that tying or tie-in agreement at the top of page 16. This is also an antitrust law violation that says you cannot tie 2 contracts together. So if you've got a lot listed and a builder comes to you that wants to build a house on it, you cannot say to that builder, I will only sell you this lot if you give me the listing when you build the house. That's tying 2 separate contracts together. That's illegal. Now, can you sell the lot to him and list it? You can do both. You just cannot make one a condition of the other. You cannot refuse the first to get the second. Those have got to be 2 separate decisions. Let's talk trust accounts. Page 20. In the middle there, it's got to be an FDIC account with the word trust in it. It's got to be interest bearing, and the interest on the account gets transferred to the state on a quarterly basis. The bottom of page 20, earnest money checks must be deposited within 5 banking or business. It might say business, same thing. 5 banking days after the last signature on the contract. The final date of acceptance. 5 days, 5 banking days. Top of page 21, the broker is allowed up to $1,000 of their own money in the account. Now, I know we've been talking about these escrow and trust accounts. Who can have one? That we put this special money that belongs to other people, deposits and earnest money. Who can have them? A bank, an attorney, a real estate broker, a title or escrow company. They can have accounts. We've talked a lot about how commingling or conversion of that money from the trust account to a personal or business account is illegal, right? Iowa does allow, though, up to $1,000 of a broker's personal money to be in an escrow account. That way, the broker has money in there to cover any banking fees, check fees, bounce check fees that might incur like any other bank account. Under releasing trust funds, the theme of this is it's got to be in writing between buyers, sellers, tenants, and landlords. The purchase agreement will tell how the earnest money is released. The lease will tell how the deposit is released at the end of the lease. And if it's not released, why? Right? That will all be in writing with the original offer or lease. If for some reason we don't get to closing, then we need written authorization from buyers and sellers, how it's released. At the top of page 22, a broker never keeps earnest money to cover any commissions that they may have earned. That's other people's property, that's other people's money. If we've got to go after unrecovered commission dollars because someone breached the contract, we've got to get it in a different way, but not through the earnest money. And then last on that was, if a buyer writes an offer and it's never accepted, the earnest money can be released immediately. We don't need a seller's signature to release it because they never accepted an offer to begin with. Under closing a transaction, we need to know that if we write an offer, it's got to be a cashable check or cash. Anything other than that has got to be disclosed to the seller. So if you write $1,000 on the earnest money amount and the seller accepts it, it's got to be cash or immediately cashable check. Can't be anything else. If you want to use your Swatch watch collection from the 1990s as earnest money, you can do that, but it's got to be disclosed in the original offer and the seller has to accept it. So you can use an item of value, but again, it's got to be a part of the original offer, and then the seller has to accept that idea. And some sellers would not want a Swatch watch collection as earnest money. You know, crazy, but that's the law. And then on page 23, I know we see this a couple of times in this handout. A broker is responsible for keeping all records, paperwork, and bank account information for the trust account 5 years. 5 years. Now, under agency, I think that your big questions are going to come around confidential information as kind of a general theme, which is on page 26. This is a really good overview. And then I would review what it looks like to remain confidential as a single agent and what it looks like to remain confidential as a dual agent. My general synopsis, though, is we do not want to share anything that would put our client at a disadvantage when negotiating. My 3 big rocks for that is their strategy, their motivation, and their finances for writing that offer or selling that property. You wouldn't share that your buyer is willing to pay more. You wouldn't share that your seller is willing to take less. On page 27, on that second and third bullet point from the top, again, we've got to present all offers. And we've always got to disclose material adverse facts no matter what.
Give me real quick, the difference
Yeah.
between material adverse and latent defects.
Great question. A latent defect to me is the general national term. And Iowa, we call it a material adverse fact. That's just Iowa language. It means the same thing. A latent defect or a material adverse fact, those get disclosed no matter what. Even if your seller says, shh, 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 don't say it. It'll work out. It'll all work out. No, you got to disclose it no matter what. It's something of such significance, it would change the value, structural integrity, or pose an environmental issue. And it's not something that we can necessarily see with the naked eye or by a regular home inspection. So latent defect might be the language on a national exam, but in Iowa, we call it a material adverse fact. We're fun here, aren't we? My big thing with dual agency is I cannot stress that it be disclosed to all parties. You cannot do that as a secret. Page 31. This is a test question that you could see in multiple. You could see this more than once. But the law says that you can represent yourself or immediate family, but you've got to disclose it. You can represent yourself or immediate family, but you've got to disclose it. So if I'm buying or selling property, I would write agent or buyer, rather, is licensed in Iowa, or seller is licensed in Iowa, depending on which I am. If I'm representing immediate family, I'm going to write agent is related to buyer or seller, whichever applies. Contracts, page 33. You got to present all offers. I know I keep saying this, but this is the #1 rule of Iowa Fight Club. And you might be thinking, why would you not present an offer? I don't know. I don't know. I think sometimes agents think because they've already got another accepted that they shouldn't present anything else. And that's not true. Even if you've already got an accepted offer and another one mysteriously comes in, your seller needs to know about it. They maybe can't do anything with it, right? But they still need to know that it exists. Another thing on page 33 is brokerage agreements cannot be sold or inherited unless you've got written consent from your clients. Top of page 34. Your agreement commences at the date on the agreement and it ends either when you have a closing, we call that completion or performance, or another opportunity would be expiration. But your first opportunity to end an agency or brokerage agreement, like a listing agreement, would be completion or performance. You did your job, you had a closing, you had a sale, and let's hope you made a commission check, right? Again, we also know from this page that you cannot accept, receive, or charge an undisclosed commission. On the top of page 35, it talks about distribution of executed instruments. Here's what it means, though. If your client signs it, they need a copy of it. A buyer does not sign a listing agreement. That's between a brokerage and a seller, so the buyer doesn't need a copy. A buyer agency agreement is signed by brokerage and the buyer. Seller doesn't need a copy of it. Page 35, then under listing brokerage agreements. Remember, an automatic extension clause is illegal in Iowa. Everyone needs a legible copy of everything they sign. You cannot solicit any exclusive agreements that folks have signed with other agents. You cannot solicit business if it's exclusive, unless what? Unless they approach you first. Under property disclosure, page 37, this gives that definition in the middle of a material adverse fact again, or as we just discussed on the national, they might call it a latent defect. Again, it's something of such significance, it would change the value, the structural integrity, or pose an environmental issue. We cannot see it with the naked eye. We cannot discover it during a regular home inspection. We must rely on the seller to disclose it. Those items get disclosed no matter what. Even if your seller says, don't tell anyone, don't tell anyone, you got to disclose it anyway. When must a seller disclosure be signed? This is the first bullet point on page 37, and it must be signed prior to a buyer writing an offer or a seller accepting it. Remember, we had that last week as well when we talked about lead-based paint, that federal disclosure. Same applies with our state property disclosure requirement. The other thing I'm going to highlight on page 39, item number 4 at the top, if there's any changes in the property condition, you got to update the disclosure. There's a list of things that are required on the seller disclosure for residential property. I don't know that you need to memorize that list, but I do think you need to know who fills out that disclosure. A power of attorney and the executor of an estate are exempt. They don't need to fill it out. Bare land does not need to fill it out. Properties 5 units or more do not need to fill it out. This residential property disclosure is for units 1 to 4, 1 to 4 units. Now, let me be clear though. If I own a condo in a building with 11 other condos, and we each own a condo, there are 12 owners, everybody's got to fill out a disclosure. When it says 1 to 4 units, that means one owner owns the entire building that has 1 to 4 units in it. Just to clarify that. And then groundwater hazard statement. Again, this is not a real estate disclosure. This happens at closing. And it is a disclosure really created by the DNR, Department of Natural Resources, in order to track our groundwater and make sure we've got clean drinking water. We like this, right? We do not want malaria. You all agreed to that earlier. Now with that, this groundwater hazard statement in your real life, this form is changing in your career. But in case there's still questions on it on the exam, I want you to know what's on the groundwater hazard statement. It's wells, burial sites, underground storage tanks, septic systems, and hazardous waste. My way of remembering these groundwater items is G.W. Bush. You guys know who that is, right? He was president. Yeah, okay. Just checking. We used to say every morning, man, Amy, you've got no excuse to get up and not do something because Jimmy Carter is out there swinging a hammer building a house. What am I going to say now? It's still probably up swinging a hammer building a house, though. Item number 2 on that list is who can sign a groundwater hazard statement? The answer is transfer or agent. It says it right on the form. Transfer or agent. Transfer or is sellor. Sellor or agent. Another good question is when must this groundwater hazard statement be made available? And the answer is in order to record the deed. Again, this is paper that comes with closing documents at the end of a transaction, not at the beginning like a disclosure or a purchase agreement and your inspection periods. It's at the end. It's got to be made available to record the deed. If it's not made available, title still transfers to the new owner, but we're not able to put it on public record. And obviously, we want things on public record as a way to prevent theft. And we know who is the true owner of a property, but also because if anyone's getting a loan, that lender wants to be able to file a lien on that property as the priority, right? Do it right away. And item number 4, again, we're still on page 41. This says that basically the groundwater hazard statement isn't what dictates repairs. Repairs should have been made in the original offer with the original disclosure or based on a home inspection period. But at the end, if they disclose something, that doesn't constitute and require a repair. Page 42, broker responsibilities and assistance. Let's actually pop to page 43. As a general reminder, anytime we've got to send a license back to the Real Estate Commission, 72 hours. The broker has 72 hours. Once a license is suspended, you're not doing any real estate activities, whether you're a salesperson or a broker. Now, here's the challenge though. Your broker goes inactive and gets suspended. All of the licensees underneath him, the salespersons and broker associates, they're now all inactive as well. Bottom of page 44. This talks about progress reports. And this says that when someone asks about an update, you deserve to give them one upon request. There's no 5-day, 10-day, 30-day waiting period. It's upon request. The middle of page 45, your broker is ultimately responsible for you. Page 46, that third bullet point down is a good one. If a broker closes their business, they've got 10 days to remove advertising. The top of page 47, those 4 elements that must be included with advertising or marketing on the internet, including but not limited to email. Those 4 items are the licensee's full name, the full name of the brokerage, the city and state, where the brokerage is located, and where the licensee holds a license, what states. We don't need the license number. We need those 4 items. Under support personnel, know that while the broker is ultimately responsible for everyone in their brokerage, if a salesperson licensee hires an unlicensed assistant, again, broker's still responsible, but the licensee that hires them has the utmost amount of responsibility. And I would look for the phrasing exactly as it is in the book in that paragraph right under support personnel for licensees. Then I would also review permitted and prohibited activities, page 48 and 49, of what an unlicensed assistant can and can't do. They cannot select vendors. They cannot host public open houses independently. They cannot negotiate terms. They cannot relay and explain a report to someone. They can open the door for a client. They can make keys for a client. That would be my summary on that. Property management agreement. Page 50. I would know what goes into a property management agreement. We've got to identify the property. We've got to set the terms and conditions or scope of work that the agent's going to do. Are they just doing leases? Are they also doing financial and cash flow reports? Are they also ordering maintenance? What's the role? How much are you charging for your fee and when? When does the agreement again start and end? Everyone needs broker and landowner or landlord need to sign it. I would review that list. I think that could be good for you. Also under property management agreements on page 51, once your property management agreement ends, either it expires or you're terminated, your role is to contact all the current tenants, let them know who their new contact is, and where they can find their deposits. Under property management financials, you cannot transfer money between an owner's bank accounts by just writing in a ledger. You've got to actually have billings and receipts. No IOUs is what we were joking about. And we cannot put an owner's funds into insufficient funds. You should not write checks that would cause it to go insufficient funds. 2 questions in that little section. And then again, on page 53, you've got 1 question on the Iowa exam for fair housing. Now, it's going to feel like more than that because then when you go to the national, soon you'll probably have 5 or 6. We've got 1 on the state. I've given you a bullet point review in this book, but I want you to know that the original protected class was race. That's the first one that we started with. Then we've amended over time and added others. And that is our speed review summary. I'm going to stop our recording.